Hello everyone, welcome back to the channel EduTap. I am Arshdeep Kaur and today we will be starting with another rule, that is the SEBI Procedure for Holding Inquiry Penalty Rules 1995. We have already completed all the acts that were the part of your security laws, and from the last video we have started doing the rules and the regulations, right? So this is your second video on the rules, and these are the procedure for holding inquiry, and these are the procedure for holding inquiries and penalty rules that is under 1995, right? So I have been stressing on this part very much that the security laws, they have been given 40% weightage this time, so which is very huge. So you have to prepare for each and every act, you have to prepare for each and every rule and regulation that has been mentioned on your syllabus. Please don't take it lightly, please don't be lenient while you prepare for these. So please make sure that you prepare for them well, right? So before I start, I would like to tell you that EduTap has come up with two courses for the phase 2 examination, the first one being the test series and the other one being the live crash course, right? So what features are included in the test series? Let's find out. The first one is the chapter wise test, right? The chapter wise test includes what? It includes every act that has been divided into chapters. So you have been given test according to these chapters. Separate test for each chapter has been provided in this chapter wise test. So the second one is full length test with evaluation. So the experts, they are going to be evaluating your answers that you give in these test series. So they will be evaluating those, right? So you will come to know that where are you lagging behind. So that is why they have been given with evaluation, so that you can get necessary feedback and you can make the improvements on that part, right? So the full length test, these come with the evaluation. For the descriptive test, it is going to be very helpful to you. The other one is the one-on-one mentor support. So you also get one-on-one mentor support on this. And in the live crash course, you have this unique feature of live classes. The live classes, they have already been started, and the live classes, they are being recorded as well. So you can watch those classes later on as well. So we will be covering each and every act, we will be covering each and every regulation that is mentioned in your syllabus, and everything that is important for your examination will be covered, right? So the first one is the live classes. The second one is the short notes. So you also get the short notes in the live class, which will be very helpful for your descriptive part this time. So short notes are going to be helping you with the descriptive part. Then all the features of the test series that I have just mentioned, they are also included in the live crash course, and you also get one-on-one mentor support. So we are running a limited time period offer. So if any one of you is interested, can refer to the link in the description below. Now let's start with our lecture. Question number 1. What is the minimum period of show cause notice to be imposed upon a person on whom inquiry is initiated under section 15A, 15B or 15C? So the answer to this question is C, that is 14 days, right? So the minimum period of notice, it has to be 14 days. Let's read it. Holding of inquiries, rule 4. In holding of an inquiry for the purpose of adjudicating under section 15A, B, C, D, EA, EB, F, G, HA or HB, whether any person has committed contravention as specified in any sections, the board or the adjudicating officer shall in the first instance issue a notice to such person requiring him to show cause within such period as may be specified in the notice, being not less than 14 days from the date of the service thereof, why an inquiry should not be held against him. So in case there is a penalty that has been imposed on him, it can be for the insider trading, or for example that person has not entered into a contract where he was supposed to, or he has not furnished any information as per the given sections. So in that case, a notice of not less than 14 days, it will be issued to him, and he is required, under that notice, he is required to come and show that why such inquiry should not be instituted against him, right? So let's read this again. The board or the adjudicating officer shall in the first instance issue a notice to such person requiring him to show cause within such period as may be specified in the notice, being not less than 14 days from the date of the service thereof. So that 14 days from the service of the notice. Why an inquiry should not be held against him. So he is required to come and tell that why the inquiry should not be held against him. Every notice under sub-rule 1 to any such person shall indicate the nature of the offence alleged to have been committed by him. So that notice, it will also indicate the nature of the offence that is alleged that he has committed that offence. Third, If after considering the cause, if any, shown by such person, the board or the adjudicating officer is of the opinion that an inquiry should be held, he shall issue a notice fixing a date for the appearance of that person either personally or through his lawyer or other authorized representative. So after that person has come and he has shown his cause that why the inquiry should not be instituted against him, if after that also the board or the adjudicating officer is of the opinion that inquiry should be held, in that case what are they going to do? They are again going to affix a notice fixing the date for appearance for that person. That person is now, he has given a date on which he is required to appear, fixing a date for appearance of that person either personally or through his lawyer or other authorized representative. So he can either come personally or he can send a lawyer or any other person that is authorized. On the date fixed, the board or the adjudicating officer shall explain to the person proceeded against to his lawyer or authorized representative the offence alleged to have been committed by such person, indicating the provisions of the act, rules or regulations in respect of which the contravention is alleged to have been taken place. The board or the adjudicating officer shall then give an opportunity to such person to produce such documents or evidence as he may consider relevant to the inquiry, and if necessary the hearing may be adjourned to a future date, and in taking such evidence the board and the adjudicating officer shall not be bound to observe the provisions of Evidence Act. So now the person, he can be asked to bring some evidence or documents, and in considering those evidence the board or the adjudicating officer, they are not bound by the provisions of the Indian Evidence Act, provided that the notice referred to in sub-rule 3 and the personal hearing referred to in sub-rule 3, 4 and 5 may at the request of the person concerned be waived. So these provisions, they can be waived off if the person requests so, right? 5A, the board may appoint a presenting officer in an inquiry under this rule. While holding an inquiry under this rule, the board or the adjudicating officer shall have the power to summon and enforce the attendance of any person acquainted with the facts and circumstances of the case, to give evidence or to produce any document which, in the opinion of the board or the adjudicating officer, may be useful for or relevant to the subject matter of the inquiry. So the board or the adjudicating officer, they can compel any person to attend these proceedings who is well versed with the facts of the case, right? So in the opinion of the board, may be useful for or relevant to the subject matter of the inquiry. If any person fails, neglects or refuses to appear as required by sub-rule 3 before the board or the adjudicating officer, the board or the adjudicating officer may proceed with the inquiry in the absence of such person after recording the reasons to doing so. So if you do not appear when you were asked to appear and you do not appear, in that case the proceedings, it will be started against you, that will be starting in your absence, and the adjudicating officer or the board, they will first record the reasons of doing so, right? If a person fails, neglects or refuses, so all of these, they are included, right? Fails, neglects or refuses to appear as required under sub-rule 3 before the board or the adjudicating officer, the board or the adjudicating officer may proceed with the inquiry in the absence of such person after recording the reasons of doing so. Okay, so question number 2. A person against whom inquiry is initiated and notice served shall appear before the authority by himself, through his lawyer or through his authorized representative, or any of the above. So the answer is option D, that is any of the above. We have actually read this in previous question also. So if after considering the cause, if any shown by such person, the board or the adjudicating officer is of the opinion that an inquiry should be held, he shall issue a notice fixing a day for the appearance for that person either personally or through his lawyer or other authorized representative. Question number 3. What is the name of the officer appointed under Rule 5A of the Securities and Exchange Board of India, Procedure for Holding Inquiry and Imposing Penalties, Rule 1995? So the answer to this question is presenting officer, that is option number A. The board may appoint a presenting officer in an inquiry under this rule. Question number 4. Which of the following factors should be considered while adjudicating the quantum of penalty under section 11B? So the answer is E, that is all of these, they are correct. If we read, if upon consideration of the evidence produced before the board or the adjudicating officer, the board or the adjudicating officer is satisfied that the person has become liable to penalty. Now they are satisfied that the person, he is liable for penalty under any of the sections specified herein. In that case, while adjudicating the quantum of the penalty, the board or the adjudicating officer shall have due regard to the following factors, namely. So what are these factors? The amount of disproportionate gain or unfair advantages wherever quantifiable made as a result of that default. So wherever they are going to be quantifiable, they are going to be considered. The amount of loss caused to an investor or group of investors as a result of that default. The repetitive nature of the default. So if the nature is repetitive, in that case it is also going to be considered while adjudicating the quantum of that default. What is adjudicating the quantum of that default? It means that you have been proven guilty. As mentioned here also, you have been proven guilty, and now it is going to be decided that what is going to be your sentence, what is going to be your punishment, right? So all these factors, they have to be taken into account while adjudicating the quantum of your sentence. Every such order shall be dated and signed by the board or the adjudicating officer. The board or the adjudicating officer who has passed an order may rectify any error apparent on the face of the record on such order, either on its own motion or where such error is brought to his notice by the affected person within a period of 15 days from the date of such order. So, for example, any error has been made in that order. In that case, the board or the adjudicating officer, they will rectify it within 15 days, right? So, it is given, they will do it within 15 days. Either they can do it by suo motu, that is on their own, or they can do it on an application by the aggrieved person, right? By the affected person. For the purpose of this rule, error apparent on the face of the record shall mean any typographical errors that creep in inadvertently into the order and include such order errors that do not require a long drawn out reasoning process to ascertain such mistake. Question number 5. Which of the following is false? Every order under these rules shall be dated. Every order under this rule shall be signed by the board or the adjudicating officer. Every order under these rules shall be self-attested. Both A and B are false, or both A and B are true. So the answer to this question is both A and B, they are true. So every such order, it shall be dated and signed by the board or the adjudicating officer. Question number 6. A notice or an order issued under the Securities and Exchange Board of India Procedure for Holding Inquiries and Imposing Penalties Rules 1995 shall be served on the person through which of the following modes? So the answer is D, that is either A or B. Let's read this also. This is Rule 7. A notice or an order issued under these rules shall be served on the person through any of the following modes, namely by delivering or tendering it to that person or his duly authorized agent. So by either hand delivering it or giving it to his authorized agent. By sending it to the person by fax or electronic mail. So they can be sent by fax or electronic mail or electronic instant message service along with electronic mail, or by courier or speed post or registered post. So they can be sent in electronic mode in addition to the registered post and courier services also, provided that the courier or the speed post or the registered post shall be sent to the address of his place of residence or his last known place of residence, or the place where he carried on or last carried on the business or personally works or worked for gain, with acknowledgement due. So the acknowledgement due will also be sent. Provided further that a notice sent by fax shall bear a note that the same is being sent by fax, and in case the documents contain annexures, the number of the pages being sent shall also be mentioned. Provided also that a notice sent through electronic mail or electronic instant messaging services along with the electronic mail shall be digitally signed by the competent authority, and bouncing of the electronic mail shall no constitute valid service. So if it is being sent by the electronic mail, in that case it will be signed by the competent authority. In case of the failure of service of notice or order through any of the modes provided in Subrule 1, the notice or the order may be affixed on the outer door or some other conspicuous part of the premises in which the person resides or is known to have last resided or carried on business or personally works or last worked for gains, and a written report thereof shall be presented in the presence of 2 witnesses. So in case we have failed to deliver the notice or the order as mentioned in this Subrule 1, So in that case, we have to do what? We have to affix that notice to his last known address or where he worked lastly, or where he last worked, right? So, and it also and a written report thereof shall be prepared in the presence of two witnesses. In the presence of two witnesses, the report is also going to be prepared. In case of the failure to affix the notice or order on the outer door as provided under sub-rule 2, the notice or order shall be punished in at least two newspapers, one of which shall be in English daily newspaper having national wide circulation, and another shall be in newspaper having wide circulation, published in the language of the region where that person was last known to have resided or carried on business or personally worked for gain. So in that case, it will be published in at least two newspapers, one being the English, that is the national wide newspaper, and the other one being a regional language newspaper, right? Question number 7. In case of failure to serve notice, copy of the notice shall be affixed in which of the following places? This we have just done. It is option D, that is either A or B. Known resident of the recipient, place of work of the recipient. So in case of failure to serve a notice or an order through any one of the modes provided in sub-rule 1, the notice or the order may be affixed on the outer door or some other conspicuous part of the premises in which the person resides or is known to have last resided or carried on business or personally works for gain or last worked for gain, and a written report thereof shall be prepared in the presence of two witnesses. This we have just read. Question number 8. In case of failure to affix the notice or order on the outer door as provided in sub-rule 2, the notice or the order shall be published in at least two newspapers. Which of the following type of newspapers are referred here? This also we have done. So the answer is A, that is an English newspaper and one regional language newspaper. So in case of failure to affix the notice or order on the outer door as provided under sub-rule 2, the notice or the order shall be published in at least two newspapers, one of which shall be in an English daily newspaper having national wide circulation, and the another shall be in newspaper having wide circulation, published in the language of the region where that person was last known or to have resided or carried on business or personally worked for gain. So now question for achievers. Appointment of adjudicating officer for holding inquiry has been provided under which rule? Your options are Rule 5, Rule 3, Rule 7, Rule 2 or Rule 4. So you have to comment the right answer below. So that was all for today. I hope it was a helpful session for you. For more such videos, please like, share and subscribe to the channel EduTap. Thank you.